Well, welcome and good morning, everybody. Thanks for joining us. I'm here with my partner, Corey Higgins, and today we're going to be speaking to you about some PFML issues that we've seen come up frequently as kind of hot topics. We've received questions from folks, and this is going to be, we'd like this to be interactive. So we hope we can answer your questions about the PFML. And we want to make sure you are having fun with the PFML. So due to COVID, let me just say a few opening remarks. We have moved to this virtual environment, and so in lieu of our annual in-person employment law seminar, we're hosting a series of employment law webinars this spring. This is the third in the series, and all of them have been recorded and are available on our website and on YouTube. We're finalizing the topic and date for our next webinar, which will be in the next week or two, and you should get that invitation soon. Our employment attorneys are teaming up to present these programs, and as chair of the group, I'm proud to say that we've been working collaboratively to cover the many hot topics in employment law to keep all of you up to date on things you need to know to be successful in your roles as HR professionals and business owners. If there's a particular topic or question you have, please don't hesitate to reach out to any one of us. In addition to our labor and employment group, I'd be remiss not to mention that attorneys working, that Mirick O'Connell is a full service law firm. We have over 60 attorneys working in a wide range of areas of the law. So whether your legal needs are business related or for you personally, we have attorneys who can assist you. If you'd like to learn about the other areas of our firm, please visit our website or feel free to reach out to Corey or me. We'd be more than happy to introduce you to one of our colleagues. So today's topic, as you know, is PFML. Are we having fun yet? And Corey and I would like to make this as interactive as possible, and we encourage all of you to use the chat feature, or you could raise your hand as well and unmute and ask a question that way. We'll do our best to cover as many questions as possible. We've received a number of questions in advance of this program today, and we're going to touch on some of those in our slide deck, and a couple of that are not in our slide deck, but we also, as I mentioned, are welcoming questions as they come up today. So I should also note that as an FYI, we're recording today's program, and we'll be sending out the recording by next week. So you'll be able to watch it again if you'd like. So with that, let me just begin our first topic. Next slide, Katie. And this starts with, we just wanted to kind of, with some of these, give you some reminders of what you need to be doing. This written notice that all employers covered by this law are required to provide, it's very important that, this is part of the onboarding package for your employees. If possible, I mean, they've got to be given out within 30 days of the employee's start date, and the notices must include information about PFML benefits, contribution rates, and job protections for taking PFML leave. You've also got to include an opportunity for the individual to acknowledge receipt. That can be done, either hard copy, someone signing an acknowledgement, or it can be done electronically, but you do want to have that acknowledgement. That's very important. It has to be in the individual's primary language, and I don't know if we've got any employers online who have more than 50% of their workforce as contractors, but if you do, they've got to be given to those folks too. And I've mentioned this before in terms of the contractor piece. If you have 50% or more of your workforce that are contractors, you should call us because we've seen anyway, very few of our clients, I can't think of one offhand right now, have that kind of breakdown in their workforce, but depending on the business, it could, but you've got to be very, very careful, particularly in Massachusetts, in terms of classification, and make sure that you've classified folks properly. So because I can't tell you how many times I've heard clients say to us, well, we 1099 them, you 1099 being a verb in that case. And in fact, they're misclassifying them and they should really be employees. So a caveat on that. But in terms of the notice itself, the Department of Family and Medical Leave, hopefully you all know this, has that model notice you can use, whenever agencies, whether it's the FMLA or the Department of Paid Family and Medical Leave, have forms to use them, because you can't go wrong if you do. Next slide.
And a couple points on that first notice slide. In regard to the notice, if you fail to provide that notice, you're arming the employee with the ability to say that he or she didn't know that they could avail themselves of the rights and protections under the law. And so, in fact, Jonathan and I had discussed a scenario that recently came up where the employer didn't give the notice, and then the employee never filed for benefits, but would have been protected under the law. And it raises, a question of whether or not you can take any adverse action against that individual if you haven't given them the notice. So it's very critical that they get their notice within 30 days of the start date.
Exactly. Thanks, Corey. And that's exactly why I wanted to include this on our little, what we're focusing on today, because that is it's a pitfall. So make sure that notice is done and done properly. So how many weeks of leave can they take? And people are still wrapping their heads around all of this, because for folks who have 50 or more employees, you're used to complying, hopefully, with the Federal Family and Medical Leave Act, which is 12 weeks of leave for various reasons, all of which are covered by our new state PFML law, but it goes further than the FMLA. And one of the ways it goes further than the FMLA is that you can get up to 26 weeks of leave in a benefit year. And of course paid, unlike the federal FMLA, which does not have to be paid. And so, you could have situations where you are, there's the one type of leave under the PFML that you could get a full 26 weeks just for that one reason would be if you're caring for someone injured in the armed forces, if they're injured, and it's got to be injured overseas fighting. It's very specific. So other than that one kind of situation, the way you could get to that 26 weeks is an aggregate. So for example, if you took leave for your own serious health condition, you get up to 20 weeks for that. And then let's say, come July 1, employers are going to have to be prepared, because employees are going to have a right to take leave to care for a family member with a serious health condition. So, you could take 20 weeks for your own serious health condition, and then later in the benefit year, you could take another up to 6 weeks to care for that family member for a total of 26 weeks.
One caveat about the FMLA, the federal FMLA, if you're covered, is you could get 26 weeks for caregiver leave for a military service member, but the distinction is that it's unpaid. And here, under the new Massachusetts law, all of this is paid leave.
Yeah, thanks, Corey. That's true. That's a good point, and I imagine that's why the Massachusetts legislature built that in. The legislature looked to I think two main laws. Not to bore you with all the legal stuff, but they looked to the federal FMLA, I think, and they looked to the Massachusetts unemployment compensation system. And that's why so much is kind of similar to that when you're talking about average weekly wage and that kind of thing. So it's this kind of weird Frankenstein of a law. I think that's where that up to 26 weeks for caring for a service member injured in the armed services overseas. So again, it's just, the PFML is just a lot broader than the FMLA, and we'll be talking a little bit later about the interplay between these laws. Next slide. So this is a question that has come up frequently and was posed to us actually by a client for this program. And that is when a woman has an uneventful birth and her employer offers disability insurance, does she get the first 6 to 8 weeks as a disability/medical leave and then 12 weeks of bonding leave, or does it all run concurrently? And again, the reason this is a little bit confusing, I think, is if you're used to the federal FMLA, you're not thinking of it in those terms. You're thinking about it in terms of parental leave. Same with the Massachusetts parental leave law, which is up to 8 weeks of leave, which is, again, I'll touch on later. It's kind of, I think, obsolete now in many ways. But PFML is different. So let's just, looking at this question, uneventful birth, I suppose that means, there was no medical situation before the birth, like bed rest or something like that, where an employee was incapacitated prior to the birth. But in any event, that part, whether it's eventful or uneventful, it's going to be medical. It's going to be considered a serious health condition. So, and whether disability insurance is offered or not is really not relevant. What you need to know is that the person could get 6 to 8 weeks, and that 6 to 8 weeks, by the way, that could be, a lot of short-term disability plans provide 6 weeks of STD for a regular birth versus 8 weeks for cesarean. But I know STD policies vary or can vary in that regard, but it's really, again, later on, Corey's going to be touching on how STD interplays with the PFML benefit, but that's neither here nor there. It's the fact that someone could get that first 6 to 8 weeks. That would be the serious health condition part. And then on top of that, 12 weeks of bonding leave. So it doesn't run concurrently. That's the answer. You could get up to a total of, in that situation, 20 weeks, right? You could get 8 weeks for the serious health condition and another 12 for bonding leave.
And just, there was a comment in the chat that one of the attendees has gotten approval for 12 weeks of leave after the birth for a serious health condition and 12 weeks for bonding. And as Jonathan mentioned at the beginning, you can get up to 20 weeks for your own serious health condition if you're an employee. You can get 12 weeks for bonding leave, and if you combine them in the aggregate, it gets capped at 26 weeks. So it is conceivable that 24 weeks may be what's approved by the department. They ultimately make the determination as to the appropriate amount of leave. But in this scenario, as posed, if you have a cesarean, for example, and that's 8 weeks of leave for your own serious health condition, you can then, or the employee could then take 12 weeks of bonding leave and get a total of 20 weeks.
Right, exactly. So again, maximum could be up to 26. In this particular, with this question asked, it could be, a 20-week leave. And then the question, what if an employee does not return from PFML leave? Well, that was a question I think someone raised, emailed us ahead of time, and we've seen situations if you're covered by the FMLA, or it could be parental leave, where someone doesn't return after a leave, then you may be able to just terminate their employment. The reason I say you may be able to is because you always, this is where the interplay comes in, we'll be talking about later. You got to think about other laws that might be implicated. So if the person doesn't return after PFML, just like if someone was out on a leave of absence and their FMLA leave, the 12 weeks expired, you may, as a reasonable accommodation, right? You now put on your ADA hat. You may need to provide that some additional leave as a reasonable accommodation. If it's an indefinite leave, if the person doesn't know when they're going to be able to return, generally speaking, that's not something the law requires you to accommodate, and you could proceed with a termination. often it's challenging because I'm sure everyone on this Zoom call has heard employees say, well, I'm not sure yet, but I've got a doctor's appointment in 30 days and I'll know more then. And that in and of itself is kind of indefinite, and it can be very challenging, and it really depends on the particular situation. And we field a lot of those types of calls. But so long answer to a short question. Corey?
Just a couple thoughts there. Be mindful that if you're going to terminate an employee who's been on PFML leave, that you do have this anti-retaliation component of the law and this rebuttable presumption, which we'll touch on later on in the program, that any adverse action, including in this scenario, a termination, would be presumptively held against the employer. And so before taking that type of action, we would recommend that you reach out and have a dialogue, put the employee on notice that if they fail to return by some date certain, and it's not, you've exhausted sort of your obligations under any other applicable laws like the ADA or the FMLA, that they're on notice that that's what's going to happen. Not something that you just automatically, oops, person didn't show up, they're supposed to return to work today, now we can terminate. You kind of have to put them on notice before you do that. The other thing is, if an employee doesn't return from PFML leave and it's for the purpose of childbirth or bonding, you may also want to look at that largely obsolete parental leave law, because that requires in part the employee to notify the employer of their intention to return to work, and just see if they've complied with that as well.
Right. So, and then one just caution, if any of you have reached out to the department, they do have they have folks that you can reach. They have a call center. I don't know how many folks are in that call center, and I don't know where that call center, I don't know if you're calling Boston or it's being rerouted somewhere around the world. I don't know. But we've heard some horror stories about bad info given by those folks who don't really know the law. I think they're given a script, they're given some FAQs to answer, so just be careful. One client reported to me recently that one of the DFML reps who answered their call when asked, okay, what if an employee doesn't return after their, whatever it was, 20-week leave? And the DFML call center person said, well, you can't do anything for 6 months, which is that's obviously not the correct answer. Probably what that person was thinking is, well, you could get up to 26 weeks of leave, so kind of you can't touch them regardless of anything else, and that's just not the case. So with that, I'm going to turn it over to Corey, and he's going to talk to you about requesting leave and the application process, which we think it's, we've received lots of questions about that, and it's another kind of trap for the unwary.
Thanks, Jonathan. So I'm going to go over just briefly the application process, and after an employee gives notice, and by way of background, an employee or a covered contract worker, if that's your scenario, that individual has to give notice to their employer at least 30 days in advance of the anticipated start date of the leave, or as soon as practicable if there is a delay that's beyond the individual's control. The employer's usual and customary notice and procedural requirements will apply absent unusual circumstances. And then if an employee fails to follow those requirements, leave may be denied by the department. And keep in mind that the department is the entity that's giving or granting or denying leave. It's not the employer, at least if you're paying into the trust fund. If an individual is planning medical treatment, they have to consult with the employer and try to make reasonable efforts to schedule that treatment that in a way that doesn't unduly disrupt the employer's operations. That would be subject to their approval of their healthcare provider. But once they give all that notice or satisfy those notice obligations to their employer, the individual then has to file an application for benefits with the department no more than 60 calendar days before the anticipated start date of their leave, unless, absent unusual circumstances, but no more than 60 days in advance. The department issues the application forms. I understand that they are available on their website. You can also call into their call center, I believe, and initiate an application for benefits. There are certain certifications that are required depending on the nature of the leave that's being applied for. We're not going to touch upon those, but if you go on the department's website, you can find the specific certifications. They're also laid out in the regulations. Next slide. So once the department receives an application from an individual, it will then reach out to the employer and ask for information, and the employer will be required to provide responses to the department's information request within 10 business days. The type of information that the department asks of employers or the individual's wage and or earnings info over the last year, a description of the individual's position, the individual's weekly hours worked, the amount of leave that's already been taken during the benefit year, and any other relevant information relating to the claim, including evidence of a potentially fraudulent claim. Next slide.
Corey, before you go on, we just got, well, let's address a couple of the questions in the chat. Shelley writes, we've had multiple situations where DFML is so delayed in approving a leave that an employee goes out before we get a final approval. Is there any recourse to these situations? You know, I think that this is, we expected this and we're seeing it, which is that this is not a well-oiled machine yet. The department is, you know, this is a huge law and with you know, and that was kind of unprecedented. And I think they probably prepared as much as they thought was necessary, but I think they're a little bit probably overwhelmed right now. So I'm not surprised that there is a delay, but at the end of the day, you know, you can reach out to the DFML and see if you can find out, get a status, get an update. I know I've had clients do that about the approval, but you're well advised to provide the leave, even if it hasn't been approved yet. And obviously, if other, you know, don't forget, you know, you always have to keep in mind if you're an FMLA covered employer that could come into play as well, or other laws like the ADA and accommodation and that kind of thing. So it could be that you don't get that approval until the leave has begun.
And the other thing to note, under the regulations, it's actually the slide that Katie just clicked to. The department's supposed to provide a notice of whether the application's been granted or denied, or that it's still working because it needs additional information. But that's supposed to take place within 14 days after it receives the application. And then within 14 calendar days after approving an application, that's when benefits will start being paid. So that might be fits and starts right now at the department level because it's sort of making it up as it goes, so to speak, or the growing pains phase. But they should at least be notifying the applicant and hopefully the employer that they need more information 2 weeks out from the date that they receive the application, so that folks know that they're working on it. There's another question here. Bear with me a second. Must the employee give notice to the employer before contacting the PFML office, or can they just go directly to the state? The regulations require employees to notify their employer, to give notice to their employer at least 30 days in advance of their anticipated start date. And they're supposed to do that before they contact the department to file an application. There's another one, Jonathan, here. Are leave notifications the same in the case where we have decided to privatize the PFML policy through a third-party insurance company instead of working through the state? I would think that would be governed by the private plan. Who gets
that's correct. That's exactly right. You got to look to what your private plan has. And just, you know, we're not really covering a lot of stuff about private plans today, but I want to say a few words about it very quickly. First of all, my understanding from the department is that they have had over 4,000 employers with private plans, which frankly, I was not expecting. I was not expecting the number of clients we have to have purchased private plans. I thought folks would see how it works in the state system for a while, and then depending on that in the first year, maybe look to a private plan. And that's just not what happened. So, and what we've seen with private plans is that there is a fair amount of variation. We'll talk about that. Well, I'll mention it right now. Corey's going to talk about paid time off benefits, and because there are a lot of questions about that have come up. I use that right now just to illustrate where there are, under the state law, what we understand is the state, if someone wants to use vacation time when they could be receiving PFML benefits, you can't have your cake and eat it too. You gotta choose. Well, private plans, many of them follow the state law to the letter, and others vary. And that's one of the ways we've seen the variation where, and I'm not surprised, where these insurance companies are like, we don't care. If the employee wants to use vacation or sick time, not just during that first otherwise unpaid a 7-day period, but to supplement the benefit, to bring it to 100% of the person's pay potentially, then many private insurance plans don't care about that, and it won't affect the person's eligibility for the PFML benefit under that private plan. The other thing I want to say is I would be remiss to not mention the fact that we have put together, and I'm going to give Corey most of the credit for it. It was a team effort, but Corey did a phenomenal job putting a PFML policy, our model policy, together. You're not going to get that model. You'll get other forms from the state. You're not going to get a policy like when the sick time law rolled out and the state provided a model policy. So we have a policy for PFML that is consistent with both the state law if you're in the state system, and also we've done many PFML policies, which is our model policy just tweaked and edited to comply with the particular private plan that our clients have purchased. So if you are interested in that, please reach out to us after the webinar, and we'd be happy to discuss providing a policy for you. But we have now provided many of those to clients.
And on that private plan side of things, just keep in mind, if you are utilizing one of those, it provides the same level of protection. There's appeal rights that employees have, that they can go to the state. The state has oversight and audit authority over your plan, even though they're not administering it. But to Jonathan's point about the distinction between a private plan and the state plan in terms of the ability under a private plan to permit employees to use accrued paid time off like vacation or sick time, that's because private plans, the threshold or the baseline for them is they have to be at least as generous as the state, but they could be more generous. And so that's just some 10,000 foot overview on private plans. If we could go back to the current slide. So I mentioned the first two bullets. I'm not going to reiterate those. Those deal with the timeline that the department's supposed to hold to in terms of determining whether or not to grant an application, and then to start commencing payments for those that are approved. One key point to note, though, at the bottom of this slide is within 10 days after receiving notice of an approved application, employers should send employees a list of the essential functions of their job, because that's one of the things under the law that you can require that an employee be fit for duty to return, but it requires that you send them a list of their essential functions so that they can bring that to their healthcare provider. So next slide, please.
We had one question in the chat that just said, is our policy available as a download? It's not. It's something that you need to reach out to us, either email me or Corey, or give us a call, and we'd be happy to talk to you about that.
And one point on that, if it's a private plan, there is no one size fits all. So it's a starting point, but it's not something that you could just plug and play, because every single private plan is different, unless you buy the same plan from the same insurer. But there, as Jonathan pointed out, there's a lot of flexibility within the private plan universe. So
Right. So if you want a policy and you have a private plan, then what we're going to ask you for is the documents you received from the insurance company, and we take those and we pull from those documents what we need to put into to customize your policy.
That's right. So the next slide is actually a question that one of the attendees had sent in prior, and it's, what can an employer do if an employee starts an application for paid family medical leave benefits with the state but doesn't finish it? Initial high-level thoughts, the state can certainly delay the processing, and will delay the processing of the application and the leave. And if it languishes for too long, ultimately that may be denied. It certainly hasn't been an approved claim. But if you're also covered under the family medical leave law, parental leave law, the ADA, while that application is still pending at the state, you still have to comply with your other legal requirements to make sure that you're complying with whatever the certification process is under the FMLA, wherever that happens to be. The interactive process under the ADA, if that's applicable, if the individual would be a qualified individual with a disability. And so it's not as simple as just denying the leave and maybe taking disciplinary action, because you may still have these other outstanding obligations where you don't want to draw a claim of retaliation under those other statutes. So I think it's a continued dialogue. I would recommend that you notify the employee that their application has not been completed or hasn't been finished, that you would nudge them along to try to get them to do whatever they need to submit a final application to the state. And then if that doesn't work, then at some point, after you've exhausted your obligations under the ADA and these other laws, making sure you complied with them, then you put them on notice that you're not protected right now. Your claim hasn't been acted on, it hasn't been approved, and if you fail to abide by your obligations under the law, we'll have no choice but to treat it as though it's an unexcused absence and take it from there. But a lot of notice and dialogue on the front end so that you're not looking like you're retaliating against them for trying to exercise their right under the law. I'm going to turn it back to Jonathan to talk a little bit about the interplay in a little more detail than what we've touched on so far between the new PFML and these other laws that are also in play.
Thanks, Corey. Yeah, and before we go on to the interplay, I just want to mention a scenario that we got from a client this morning that we found very interesting, and initially kind of, we had to give it a little extra thought and check ourselves on it, but I think we have the answer. And here's the scenario that was posed. As I mentioned earlier, on July 1, the rest of the law is going to go into effect, which just means that an employee may be eligible to take leave to care for a family member with a serious health condition. And family member, among other things, when you're comparing the PFML with the FMLA, the definition of a family member is much broader under the PFML and includes siblings. So the question posed to us was, okay, employee says my sister is giving birth on July 5th, is due on July 15th to give birth. So in other words, after that part of the law goes into effect. And she wants me to be her doula and support her in the birthing process. Would that employee be eligible for PFML leave in that scenario? Well, it's not bonding leave because it's not that employee's child. However, it is, pregnancy or pregnancy-related conditions are going to qualify as a serious health condition under this law. So for that sister who wants to be the doula, we do think she would be eligible for some amount of PFML. Now, you know, do you really need, how much time off do you need to do that? And, you know, so as a practical matter, I'm not sure, maybe it's just a day or two. But it was just a very interesting hypothetical, and those are the kind of scenarios that are going to come up. So yeah, let's move on to the interplay with other types of leave. We touched on it a little bit, and because we really want to hammer it home that you've got to now, it's like you were juggling, right? Okay, we're juggling. We've got the ADA ball in the air, and or maybe the parental leave ball and the FMLA ball, if you're covered by that. And now we've got another ball thrown us, and now we got to juggle that too. You got to keep them all in the air at the same time, meaning you really have to. You can't be myopic and just think, okay, we gotta focus on the PFML because of how these other laws may come into play. So the good news, and it would have been shocking if this weren't a law, but PFML can run concurrently with other applicable state and federal leave laws, including the Parental Leave Act, which, as we've mentioned earlier, is virtually obsolete right now. I still, in the handbooks we still put those policies in, but I put a notice up at the top just saying, look, if the PFML applies here, that's what governs this thing, the parental leave law in Massachusetts. Interesting, just after decades of guys not being covered, right? They amended the law in 2015 to add men for parental leave, and then now that's now of course both genders are covered by this new PFML law. So if the leave is for a qualifying reason under one or more of those laws, then they can run concurrently. Next slide. But there's always a but, right? With FMLA, all right, you know, I wish if I were in a group of you now and we were live, which of course is what we much prefer, I would say, you know, show of hands, how many of you, if you're covered by the FMLA, how many of you have a benefit year based on a rolling look back? My guess is that, or if you haven't changed it, right? My guess is that everyone would say yes. I mean, I can't even think of a client who chose another 12-month period. Because you can under the FMLA. It could be calendar, it could be fiscal, it could be whatever. You just got to stick with it unless for some reason you make a change. And the PFML 12-month period is only forward-looking, meaning, okay, Corey says he needs a leave today, or he has a leave coming up whenever it is. From the time he takes that leave, forward-looking 12 months, that's how we determine how much of his whatever of those 26 weeks under the PFML he might be eligible for. So if you want your FMLA policy and your PFML policy to run concurrently, you have to change that 12-month benefit period in your FMLA policy to forward-looking. And so, you know, this is the kind of thing that, you know, we're in this kind of transition period right now where there's some kind of strange little anomalies that pop up, and that's what we want to address here. So if you're going to make that change, and if you are covered by the FMLA and you don't already, if you have a 12-month forward-looking policy, FMLA policy already, let me know. That's amazing. And you don't have to do anything, but like I said, that's rare. It's always that rolling look back. So if you're going to make the change, and we think you should, you've got to give employees 60 days notice of that change. So you'd say, okay, effective today, April 29th, 2021, we are changing to a forward-looking 12-month period. You can reach out to us, by the way, if you want some help with language for that notice to employees. We've been helping our clients with that. So you've got to give them that notice, and then during that 60-day period, you've got to just make sure if someone takes an FMLA leave during that period, that they're not prejudiced by the change, that they're not going to be negatively affected in any way. They're still going to get their FMLA entitlement. But again, I just think it's even though it's a little clunky with the 60-day notice, you should do it because you do want I think you want your FMLA and PFML leave to run concurrently and not consecutively. Next slide. So here's this scenario that frankly I've got right now with a client, and it's very challenging. So an employee takes several weeks of FMLA leave during the last few months of 2020, or maybe the last few weeks or very end of 2020. First question, would the employee still be entitled to the full up to 26 weeks of PFML leave in 2021, or would they get the full, for the first quarter of 2021? Could they get, for example, if it was a serious health condition and they took 12 weeks or 10 weeks or whatever in 2020, would they get up to the 20 weeks for a serious health condition rolling into 2021? And the answer is yes. Employers don't get credit, even if it was continuous. They don't get credit for that leave they gave in 2020. And now here's the kicker, here's the tough one. So let's say the FMLA continues into 2021, and that could happen, by the way, in an intermittent or reduced basis. Doesn't have to be continuous. That could really complicate things. And then you follow our advice and you change to that forward-looking 12-month period for FMLA, so your PFML and FMLA run concurrently. Would the employee then get another 12 weeks of FMLA leave because you're now going to forward-looking if they've just taken 12 weeks of FMLA leave? And this is one that, based on our review of the regulations, we think the answer is yes. You employer decided you wanted to make that change. You may have a very, very good reason for doing that, but the result of it could in fact be that the employee gets another 12 weeks potentially of FMLA time. So just to kind of double and triple check, I have a very good contact at the Department of Labor, and that's the federal agency that enforces the FMLA and does audits of employers' policies and whatnot. And I stumped that individual a little bit. And so he said he was going to get back to me just to make sure there wasn't some way to kind of, if not grandfather, then give the employer credit in that type of scenario for that FMLA. Because it's certainly, and he said to me, I know it's not fair, because someone could get, it really is a lot more than the law contemplates, but it's this kind of strange anomaly. So hopefully none of you have that situation right now, and it's just that one client I'm dealing with. But if you do, let us know, because it can be a challenging situation. But again, as we move forward into 2021 further, these kinds of things will kind of work themselves out and iron themselves out, which is why we still think it's important to get that notice out to employees, the 60-day notice, as soon as possible.
We have a couple questions that have been entered into the chat. The first one is a family member, a grandmother, eligible to take paid family leave to care for her healthy daughter after the daughter gives birth to the grandbaby? And if it's to care for, as of July 1 of this year, 2021, if the grandmother is taking leave for the daughter's serious health condition, assuming that the daughter qualifies, while she's recovering, then yes, you could take that leave for that period while the daughter is recuperating from the serious health condition. If she's healthy, though, if it was like an adoption, you're not going to be able to do that. So the question's a little bit loaded, but if there's leave to care for a daughter as a result of a serious health condition, which is recovery from childbirth, the answer would be yes.
But not bonding.
Not bonding, exactly.
Which is what we were talking about with the doula, sister
That's
doula
right.
Hypothetical.
That's right. Next question was, does the PFML apply to part-time employees? The answer is yes, it applies to all employees. Seasonal, part-time, temporary, full-time employees.
Corey, I'm glad we got that question, because it reminded me to tell everyone that the dollar amount, there's so many ways the PFML is broader than the FMLA. One of them is got the question a lot, do you have to have a certain number of employees to be covered? Answer, no. Does the person have to be employed by you for a certain period of time before they become eligible, like the FMLA, where you have to be employed for at least 1 year and have worked 1,250 hours in the previous year? Those are the threshold eligibility requirements for the FMLA. Not so with the PFML. What we have with the PFML is actually, again, here's where the law is kind of based in some part on the unemployment comp system. And so in terms of eligibility, you just look to whether the individual has earned a certain amount of money in the previous quarter. And when this first went into effect, that dollar amount was $5,100. It is now $5,400. So we had done a lot of policies. If you received one of our policies initially, you saw that $5,100 number. Change that 1 to a 4 because it's $5,400. We've confirmed that because there's confusion. There's actually a DFML brochure to hand out to employees that uses $5,100. So, which is why we were confused about this, but we've now confirmed that number is $5,400, just a few $100, but and I think it went up by $300 to account for it tracked the unemployment comp. You get that $300 extra dollars now in your unemployment comp benefit, but we're told that it's not going to go down when that $300 unemployment benefit ends. So, that's the moving target. Some of these things are going to change. The department's going to change things. So contribution rates can change, and so can eligibility. So, if an employee has earned that much on day 1 of their employment, day 2, they could apply for PFML. And so, that's just kind of is what it is, and can be frustrating to employers, but don't shoot the messengers, as we say. Anyway, Corey, I'm going to turn it over back to you for a discussion about the use of paid time off during PFML.
Thanks, Jonathan. So here's another question that was posed in advance of today's webinar. Can an employee receive PFML benefits and also use their paid time off, and by paid time off, accrued paid time off, such as sick leave or vacation time, in order to get 100% of their pay? Not under a state plan. If it's, I'll start with the private side. If you are under a private plan, it'll depend on what the terms of your private plan state. But if you're paying into the state trust fund, the answer is unequivocally no. With the one exception that during the 7-day waiting period before you start receiving PFML benefit payments, an employee could, at their own choosing, elect to use accrued sick or vacation time to be paid during that interim period, that 7-day waiting period. But once you're in receipt of, or the employee's in receipt of PFML benefits, they may not also supplement with accrued paid time off under the law. So there's a section in the regulations that deals specifically with substitution of accrued paid leave. And it specifically says that covered individuals who use accrued paid leave, such as sick or vacation time, or leave through an extended illness leave bank program provided by their employer, rather than receive a paid benefit under the law, a paid PFML benefit under the law, shall not receive any paid PFML leave benefits pursuant to the law for the period of time for which they receive accrued paid time or leave through an extended illness leave program from their employer. And the accrued paid leave or leave from the extended illness leave program that is provided by the employer shall run concurrently with any leave available under the law. It's all at the choice of the covered individual, the employee. It's the employee's choice to elect to use their accrued paid leave through or instead of receiving paid family medical leave benefits. Employers have to, and if you're a covered business entity, meaning you have the contractors as well, you're required to inform your employees or covered contract workers who choose to use accrued paid leave or leave from an extended illness leave bank program provided by the employer, that the use of those leave accruals will run concurrently with leave under the PFML. So they have to be given that notice so that they know that they can't double dip down the road after they've exhausted their sick or vacation time. It is all going to run concurrently with the law.
Corey, we have one question in the chat, which is, if an employee is out on PFML, do they still accrue their time off benefits? And so you are required to maintain whatever they've accrued. They can't be divested of anything they've earned, but it's up to the employer to determine whether the accrual clock is going to continue to tick or not, which is the same as, under the FMLA. But the caveat is, be consistent in terms of what you're doing for the PFML. It's better be consistent with what you're doing for other types of leave. You want to treat all the leaves in the same way. So if you decide that during the PFML period, you want to stop the clock on the accrual, well, make sure that's how you treat other types of protected leave too.
Right. So next slide, substitution of employer provided leave. An employer will be reimbursed by the state. This is only for the employers that are paying into the state fund, not private plans. An employer will be reimbursed out of any benefits due to the individual if the employer pays an employee from a temporary disability policy, paid family or medical leave policy, or an extended illness leave bank, but not accrued paid leave such as sick or vacation leave. Please also note, though, that the regulations in this area specifically state, and I'm going to quote it, that in no event shall the department reimburse an employer or covered business entity where the covered individual has received a benefit from the trust fund for the same period of time. So if you have a scenario where an employee receives PFML benefits, but they're also in receipt of benefit payments under a temporary disability policy or a paid family or medical leave policy, such as a parental leave program that the employer provides, you're not going to get reimbursed from the state because they've already paid those benefits, and they're not going to reimburse you. It's only if you pay this in lieu of them receiving state funds through the trust fund. The next bullet, if an individual uses accrued paid leave or leave through an extended illness leave bank provided by their employer, they, as I mentioned in the prior slide, they do not receive PFML pay during the same time, even though PFML and the accrued leaves would run concurrently. Next slide, please. This is reductions in the weekly benefit amount. Regulations also provide that the weekly benefit amount for a period shall be reduced, meaning the PFML benefit will be reduced by the amount of wages, wage replacement, or leave that a covered individual on family or medical leave receives for that same period from any of the following. Any government program or law such as workers' compensation or unemployment benefits, other than a permanent partial disability incurred prior to the family or medical leave application for benefits, leave under other state or federal temporary or permanent disability benefits laws, leave provided under a permanent disability disability policy or program of an employer or covered business entity, or, and this one's where it gets a little bit tricky, unless the aggregate amount a covered individual receives, and by that they mean when you combine the paid family medical leave benefit paid from the trust fund in combination with what I'm about to read. So unless that aggregate amount the individual receives would exceed the individual's average weekly wage, the weekly benefit amount, weekly PFML amount for a period won't be reduced by the amount of wage replacement that covered individual receives for the period from either a temporary disability policy or program provided by the employer or the covered business entity, a paid family or medical leave policy of the employer or covered business entity, such as a parental leave policy that is not paying out based on accrued time off, but instead is just out of the generosity of the policy, doesn't need an accrual basis, or any wages received from another employer or covered business entity, or through the individual's own self-employment. If in those three scenarios, the temporary disability policy or program from the employer, a paid family or medical leave policy from the employer, or wages from some other source, there will not be a reduction in the PFML amount unless and until the combination of those other sources of funds with the PFML benefit exceeds the individual's average weekly wage.
So Corey, let me just jump in on this, because definitely we've gotten tons of questions about, well, we've got this short-term disability policy and you know, can it be, you know, can the employee get that benefit on top of the PFML benefit? As Corey just said, that's, you know, the answer is yes, up to 100% of the person's average weekly wage. So they can use it to top it off under the law, but it's the policy you've got to look to. You got to, you know, so talk to your broker, look at your policy, and just see what your insurance company permits, because they may have an offset. You know, that's all going to be based on your STD policy, and there may be some offset when there's income coming in from the state for the PFML benefit, or from a private plan. And we've had a lot of clients that have their insurance company provides both the PFML benefit and the STD benefit. And so they've got and that should be more clear. At least you're talking to one company and they have an approach in terms of what they're going to allow, but that is completely dependent on your STD carrier.
And some STD policies have a disclaimer that say that they won't apply in the case of receipt of benefits from some government program, and it may be interpreted that the PFML benefit is going to supersede the obligation of them to fund the same purpose under their policy. So you need to read the fine print on the policy for sure.
So we had a question from Bethany. Is the employee responsible for informing the state that they're receiving pay from the employer, that they are not that way they are not receiving money from the employer in the state? So, you know, my understanding is that, yeah, I mean, it kind of like when you apply for unemployment benefits, right? You've got to report to the state if you're receiving any other income and et cetera. So that can be taken into account in determining what the benefit is. The same with the PFML. And you don't have to, as an employer, you know, it's not something you've got to just leave to the employee to be honor system on that, right? Because the state is going to, and if it's your private insurer, if you've got a private plan, you're going to be in the loop on this. So if you're paying out anything else to the individual, then you can report that to either the state or your private plan.
And also, if upon receipt of an application for benefits, the department should be reaching out to employers with an information request, and that should include questions about what wages have been paid and what leave has been taken. So it may also come from the employer as to, you know, whether the employee is continuing to receive payments in some way, shape, or form, whether they're benefits or wages, wage continuation.
And Corey, we've got question from Diane in the chat.
It says, we provide PTO upfront in January for the year. If an employee's status changes during the year, we can adjust as necessary. Am I legally allowed to deduct the amount they would have accrued during their PFML? I think to Jonathan's earlier point, if you don't make that deduction for other types of leave, whether if you're covered by the FMLA or some other legally protected leave, or if someone doesn't have leave deducted for an unpaid leave of absence, such as a sabbatical, if they're allowed to maintain the benefits that they had prior to leaving on the leave, then the answer would be no, because otherwise you look like you're retaliating against the employee by reducing the amount that they would have accrued. There is language in the law and regulations, though, that does suggest that an employee keeps what they earn prior to going out on the leave. So to your question, it may be, I think there might be some risk that it could be interpreted as being retaliatory because you've reduced whatever they had available by virtue of the fact that they were out on this leave. I don't know if you have any other thoughts, Jonathan, but I'd be careful that would be interpreted that way.
Correct. So we've got one more slide on reductions, and then we're running a little short on time. So we may, I think you kind of covered this already anyway, Corey, or?
Yes, I covered this. Yeah, this slide was covered.
So let's move on to terminations during or after the PFML leave. And, you know, a question that we received in advance of this from a client is, are there any situations in which an employer may discipline or terminate an employee during or within 6 months after the PFML leave and not have it be considered retaliation? So, well, the answer is yes. It's just you know, we've got to be more careful than ever. So let's go to the next slide, and you'll see what I mean. And we, you know, this is the kind of thing we just can't emphasize enough. So sure, I mean, someone could be out taking a leave of absence, and I have a scenario, I have a situation, a real situation. Actually, it's an HR manager who was out on leave, and while she was out on leave, her company discovered a number of things that she had failed to do that put the company in really serious legal jeopardy. So, because that person is on PFML, are they insulated? Do they have this immunity, and are they untouchable? And the answer is no. Whether that, you know, whether we're talking about PFML or FMLA or ADA, right? So, you know, you're not, your hands aren't tied. You can discipline that individual, but this law is really unprecedented in our experience. So, for example, for a discrimination claim, the burden of proof to prove that you've been discriminated against under the law is always on the employee, always on the plaintiff. And then there's a burden shifting, you know, you go through that whole kind of determination in terms of determining whether there's actual discrimination, and et cetera, et cetera. The difference with this law is there is a presumption. It's a little bit of guilty until proven innocent, meaning if you take any kind of adverse action, and in many cases it would be a termination or discipline or demotion or whatever, but you know, during a leave or within 6 months following that leave, it's going to be presumed to be retaliatory. And you know, of course, the employer can rebut that presumption, but that evidence, it's got to be clear and convincing. So just to give you a little bit of a evidentiary primer here, right? You've all heard of beyond a reasonable doubt. You hear that all the time for the criminal burden of proof. So that's the highest. For discrimination claims, it's a preponderance of the evidence, right? And again, the plaintiff has to prove by a preponderance of the evidence that discrimination occurred. In the middle of that is clear and convincing. So clear and convincing is one step below beyond a reasonable doubt. So, and again, that's on the it's the employer's burden to prove that. So the answer to the question is, yeah, it's, you know, it's going to be presumed to be retaliatory, but it doesn't mean you cannot successfully rebut that presumption. And that's why it is more important than ever that your managers and supervisors are trained properly on you know, documenting things contemporaneously, what to document, what not to document. That disciplinary warnings are done timely, and so that there's a, for lack of a better phrase, a paper trail. So you can show, if you have to prove, and you will, because the burden of proof is on the employer to prove by clear and convincing evidence that the action you took is legit. You want to make sure that that is really processed and documented properly. That dovetails with performance evaluations. As much as I've, you know, over the years, I've done a lot of training and counseling on this. It's incredible how many times I ask a client who wants to terminate someone for poor performance, has there been any progressive discipline? Well, no. Or I'll see a performance evaluation. I had a situation yesterday discussing a termination and for poor performance, and their evaluation for 2019 and 2020 was stellar. So we're looking at a very, just in something that occurred and it wasn't very egregious in 2021, and they want to terminate the person. And guess what? That could be an issue. This person's in his 60s, so you think in age stuff, and so that didn't implicate the PFML. But my point is that it's more important than ever to make sure you get this right. Very, very, good, solid HR practices. To that end, I have for years, and even since this law went into effect, I present a 2-hour management training that I've done obviously for years in person, but I also have done virtually through webinars, and it's worked very well for managers and supervisors, kind of soup to nuts, from the interview process, what to ask and not to ask, right through termination and everything in between, and including proper documentation, what goes into that documentation, what shouldn't, etc. And because you really need, those are your front line, right? Your supervisors and managers. Those are the folks that can either help you protect the company or put the company in harm's way. So I really can't emphasize that enough.
And if I can chime in with a scenario that has come up recently for me, an employer had a situation before this law took effect in January where it was in the middle of a verbal or written counseling session where the employer was putting the employee on a performance improvement plan in addition to disciplining the employee. And the employee walked out of that meeting midway through it, claiming to have an anxiety attack or something, some medical episode, goes out on FMLA leave in December and converts that to paid family medical leave once the law takes effect on January 1. That employee returns to work at some point thereafter. And the question was posed to me, can we proceed with the performance improvement plan that we were in the midst of presenting on the date that the employee went out on leave? And to Jonathan's earlier point about being required to show through clear and convincing evidence that the action taken had sufficient independent justification and wasn't retaliatory. The key issue there is that you have contemporaneous evidence that would have shown that the performance improvement plan was contemplated internally before that person went out on leave, that there's emails to that effect, that the performance improvement plan was drafted beforehand, so that if you can show a paper trail that this decision was made before the individual went out on leave, before the employer was on notice that the employee needed the leave, then that would go a long way to show that it has nothing to do with it and it's not retaliatory. But those scenarios will pop up, so be aware of them.
Right. And next slide, just as we're wrapping up here, I'm not going to go into this. And by the way, we will email the slide deck out to all the participants. So you'll have that as well, and you can review what's on this last slide in terms of anti-retaliation. But it's really an important thing, and we just fully expect that, and it's still early, right? It's only April. The law went into effect January 1. So, later this year, we're going to start seeing court cases or claims filed at the MCAD and then removed to court that you're going to see a combination of claims of disability discrimination, perhaps FMLA retaliation, and plaintiffs' lawyers now have more arrows in their quiver with the PFML, particularly with this presumption of retaliation and interference. So we are, Corey and I are both litigators as well, and we're fully expecting the plaintiff's bar to be very active in that regard.
There's one final question that I think I just want to clarify, and it's as follows. We approved a 12-week FMLA for a January 2021 birth. The employee then applied and was approved by PFML, so I interpret that as by the department, for 12 weeks of bonding leave starting after that. Could we reduce the could we have reduced the FMLA to a max of 8 weeks for the max of 20 weeks instead of the 24 weeks that she ended up taking? I would say that if the Department of Family Medical Leave approves a 12-week serious health condition leave and a 12-week bonding leave, then there's a risk that if you reduce the 12 weeks, because it's consistent under the FMLA, although there is that distinction because the FMLA is capped at 12 weeks total, and state law provides up to 26 weeks, 20 weeks for your own serious health condition and 12 weeks for bonding, but no more than 26 in total. So I don't know that you could reduce the FMLA to a max of 8 weeks because the FMLA really would have run out after 12. So I don't know that you can do anything with that. FMLA is capped at 12 for these purposes. PFML is however long it was approved and taken by the employee in accordance with the department's authorization.
And Corey, we had a question from Ann Bordeaux. What is the waiting period for an employee for an intermittent PFML leave? How many hours do they miss before they receive the pay? And I mean, I think that would be 7 days worth, right?
But I think it's 7 calendar days. I don't think it's 7.
Right. That's right.
7 episodes.
And I think you addressed Suzanne's question, right? Or no?
Employee gave birth in 2020.
No, we didn't. Sorry.
Okay, so employee gave birth in 2020. Employee requests bonding leave in July 2021 for the 2020 baby. Employee expecting child in November 21. How will the 12-week bonding leave be handled for the 21 baby? So you get a total of 26 weeks in the benefit year. So if the employee if the employee still has available leave time for the 2020 birth, which they will, because PFML started in July, or strike that, January, just reading the slide. So since PFML kicked in January of this year, the employee certainly could take 12 weeks of bonding leave in July for the 2020 birth. And then in November of 2021 could take however much time through the end of 2021 to get to a total of 26 weeks of bonding leave. And there might also be serious health condition recovery leave as well for the birth event as well. So you could take for both occasions bonding as long as you haven't taken any other leave, and it's capped at a total of 26 weeks.
And finally, from Michael, the question is, can you provide some information on that 2-hour training you offer? And happy to do that. We have actually a brochure that covers the topics that we cover in that training. So just you've got our email and contact information on the first slide that we're gonna send you the slide deck. So don't hesitate to, here we go, perfect. Don't hesitate to reach out. But for that training, just so you know, we don't put a premium on that. I charge my regular hourly rate, which is currently, I think it's as of May 1, it'll be $4.85 an hour. And so you can kind of just do that math. So it's not really, it's a very small price in the scheme of things in terms of what the value you get from that training, which again is interactive. As soon as if we're safe to be in person again, I'm happy to, particularly now that I'm fully vaccinated, I'm happy to come to your place if folks are there, or else do it via, I've done it via Zoom, I've done it WebEx, I've done Teams. It doesn't matter what the video conferencing platform is, and it's worked. Would be happy to talk to you about that if you reach out. Any let's see, we do have Carol who I can see. Hi Carol, I can see you in the video. If the employee is out, doesn't pay for their portion of the health insurance, can the insurance be terminated? So Carol, thank you for asking this question, because I have had a number of issues recently with this, and because of not to go down another rabbit hole with the COBRA subsidy under the American, the ARPA, the new federal Recovery Act, but that kind of dovetails with it too a little bit. But at the end of the day, if the person doesn't pay for their insurance, you got to give them notice, got to give them at least 15 days notice if they're late with the payment. And if they don't pay their regular portion, and this is true of FMLA, PFML, what have you, then you can cancel them. You can cancel that. And what a lot of folks, I think, don't quite understand is that's not a COBRA qualifying event. It's not, you don't cancel their insurance and then give them COBRA notice. So if you cancel them, that's it. You want to be really careful, of course, before you take that step, and make sure you get it in writing and clear that the person's received that notice. But if they don't pay, yes, they can be canceled.
The only thing I'll chime in on is if you've let other folks lapse in their insurance payments while they're out on some other leave, be careful for an anti-retaliation claim if they're taking leave under the PFML.
Yeah, that's a really good point, Corey. And we see that, we see these situations where a client will say, geez, Jonathan, the person's been out for 6 months. Oh, okay. And they stopped paying 4 months ago. So we've been paying 100% of the premium. And you really want to stay on top of this. I just don't think it's a good idea to, and I understand clients they're being generous by doing that and keeping that, particularly if the person's out for their own serious health condition, they need that health insurance. But the law is very clear, and your policy should be too, that they have a responsibility to pay their portion of the health insurance premium. And if they're getting the PFML benefit, then they've got money. It's not like, you can't deduct it from their regular pay as you do usually, and that's why folks lapse on this. But particularly if they're getting the PFML benefit, they've got money in their pocket, and that they should be able to hopefully pay their portion. And if they don't, and you've notified them, as I just mentioned, and they fail to pay, then you can cancel. But as Corey said, be consistent, and don't let it lapse. Corey, you want to field that next question?
Oh, sure. So this is from Bethany. I have an employee who applied for partial PFML due to medical reasons for pregnancy. She is only allowed to work 20 hours per week. Once she gives birth and will go out on full PFML, and she will be using accrued sick/vacation time after she gives birth for some of her leave. Does the employee need to fill out a new application at this point? That's a good question. I will say, I know that when you go out on leave for birth, you don't have a waiting period to segue into bonding leave, but I'm not sure if you need to do a second application with the department. I'm not sure what their provisions.
Yeah, my guess would be no. My guess is that in terms of, when you're in the portal and you're applying, I think the employee's got to report additional income like that, and then whether the employee does or not, the employer should inform the department or the insurance company, as the case may be. And so, for that period that the person's using their paid time off benefit, they won't be getting the PFML benefit, maybe, right? But it'll still, the PFML leave period, that clock will still be ticking. So I don't think there's going to be a need to do a new application. But
one thing though that's critical is that the employer needs to notify the employee that while she uses her accrued sick and vacation time, do this in writing, that time will count as leave under the paid family medical leave law, even though she won't be receiving benefits under the law for that period.
So, and the follow-up was, do you know how we go about informing the department? And that should be through the portal, through when you're, I don't know if you've...
PFML administrator, your employer representative.
Correct, that's right. But you should be able to do that through the portal with the department,
or call the contact center,
or call the call center. But be careful.
Famous last words.
Right. So And if all else fails, call us and we'll get you the answer. So I think that's all we have for now. I know we went a little longer than expected, but I think that shows us that folks are, I mean, you know, everyone is grappling with this new law, including yours truly and Corey and all of us here. We're trying to do the best we can. And, you know, when you get inconsistent responses from the department or incorrect answers or what have you, it just makes it that more challenging. But we have ways to get answers, even if they're not clear in the law and the regulations. So don't hesitate to reach out to us. And I just want to thank you all for taking the time this morning and joining us for this. Your questions and comments are, you know, this is how you're educating us too, and challenging us with these scenarios. And I have no doubt we will continue to be challenged as we move forward with this law. So happy to assist you. If you're already a client of Mirick O'Connell, thank you. Thank you for your business. If you're not, we'd love you to be a client. So there's our contact info. And like I said, the slide deck will go out. And good luck, and continue to have fun with the PFML as we do every day.
Thank you, and be well, everyone.
Take care. Stay well.